Okay, now we'll do Caldecott versus Superior Court.
Good morning, Your Honor. William Crosby for petitioner. In its order denying Mr. Caldecott's writ petition, as Your Honor, I'm sure, are aware, he gave two reasons. One was that the petition was moot because he already had the documents, and secondly, that what he was arguing about the hostile work environment implicated only internal personnel issues and therefore was exempt from the CPRA. Well, I'd like to address the first issue. In addition to the authorities and the reasons that I've cited in my brief, I'd like the court to consider a common defense that's proffered in wrongful termination of employment cases based on public policy, where the employer argues that, well, the employee has the confidential documents in his or her possession that he claims proves his whistleblowing, but those are confidential. And according to that doctrine, then damages can be cut off as of the date that the employer discovers that. And it's not uncommon in these cases for cross complaints to be filed against employees. So public employees, like Mr. Caldecott, I submit, have every reason, absent a public records request, to be concerned about a similar result. Now, turning to the second issue.
Well, on that issue, your position is the problem isn't getting the documents. The problem is using the documents. And the mere fact my client has the documents doesn't free him to use them in the way he wants to.
Exactly. Absent a public records declaration.
So the question is not moot, is the
Well,
point?
it's not moot. That's our position, not moot at all.
Understood.
Now, as to the second point, in addition, although the records requested were presumably reviewed by the trial court, there was no finding that any of these were in fact public records, nor was there any explicit reference to exemptions, statutory exemptions under the CPRA. Nor was there any reference to respondents, or the real party, I should say, position throughout these proceedings, both in the court below and here, that Mr. Caldecott really wasn't a whistleblower. The court never addressed that in its ruling. Yet the 94 pages of documents in issue are replete with references to alleged significant financial malfeasance. These included a number of specific references, which I indicated in my briefs, and I won't repeat here. In the declaration of outside counsel representing the district offered in opposition to the court below, at page 87, Exhibit 8, he says, quote, "I reviewed Mr. Caldecott's complaint and determined it had no merit," unquote. Not one reference to any investigation by an outside consultant, as had been promised Mr. Caldecott, and that's stated in one of the records, or anyone else. And in Mr. Caldecott's declaration at paragraph 4, he says he was never interviewed, and to his knowledge, nobody else was ever interviewed. Now, regarding the district's response, and this is stated in the letter opposition, which is one of the documents Mr. Caldecott requests, denying his complaint, he says, well, none of the complaints he made about a hostile work environments pertain to any protected status under the law, such as race or color, or protected activities such as complaining about discrimination or retaliation, and therefore it wasn't unlawful. Well, doesn't the public have an interest in knowing whether the chief administrator of a school district just might be bullying or abusing employees? And according to Mr. Caldecott, there were 3 employees involved. And shouldn't the public have an interest in knowing if there was a waste of public funds, or why this district director of HR was terminated when he raised these issues? Now, this court has requested and presumably has reviewed all of the records, including Mr. Caldecott's emails of October 14th and 19th, November 19th, I think December 3rd, and then, of course, December 11th, or in response to the request. And in these emails, he documents the hostile environment, acts of retaliation, and financial irregularities. And yes, he requests whistleblower status. And isn't that understandable? given that this district has a history of problems with high-level executives, and he was concerned about retaliation, and rightly so, as it turned out. And I think it's also noteworthy that he had been with the district for 10 years. This was the first time that he found necessary to bypass the chain of command and actually file a complaint with the board. Certainly, these were reasonably based complaints of improper government activity qualifying for whistleblowing protection. His email of December 11, responding to the district's response, describes its flawed conclusions and lack of an adequate investigation. And regardless, actually, of whether he did qualify as a whistleblower, it's our position that's really a red herring issue, because under the code, Government Code 6257.5, motive or intent is just not relevant anyway. There's one central issue that this court has before it, and that is this. May a governmental body unilaterally determine without any objective investigation that a complaint lacks merit so as to be immune from scrutiny under the Public Records Act. As the appellate court noted in AFSCME versus Superior Court at 80 Cal F 3rd 913, quote, "The court should not be bound by a contrary determination of the public agency, for if that were so, the CPRA's decree that that access to information concerning the conduct of the people's business is a fundamental and necessary right of every person in this state would be largely thwarted." And I submit that if this court affirms the order below, that the CPRA's purpose and intent would be thwarted in this case, especially not since a single word of 94 pages was not declared or deemed to be a public record. The position taken by the district in this case, I submit, demonstrates why the legislature chose to emulate the Federal Freedom of Information Act by enacting the CPRA, and why it now has constitutional status. There can be no accountability on the part of government or public officials without transparency. Having raised his reasonably based suspicions of improper governmental activity, Mr. Caldecott requested the records so that at least members of the public could make their own judgment. This court now has an opportunity to confirm that a public employee who has a reasonable and good faith belief of improper public activity takes a wise and judicious course if he or she has confidential documents by making a public records request. And that it can only be rejected as the BVR case, which is clearly on point to this case, because that dealt with a school superintendent and a board that ratified the school superintendent. And I've quoted what the court said in that case in my brief, but that should only be denied where there, as the court said, the district has met its burden of proving a clear overbalance that the public interest in favor of non-disclosure outweighs the public interest in disclosure. So I request that the court grant this petition, reverse the trial court, and either conduct an objective review of the documents, removing only clearly attorney-client privilege documents, or order that the lower court do so. And we respectfully request that a timetable be set to avoid further undue delays. Thank you.
Thank you, Mr. Crosby. Mr. Covert?
Good morning, Spencer Covert appearing on behalf of the real party in interest, the Newport-Mesa Unified School District. The factual posture of this case is significantly different from all the CPRA cases cited by petitioner and Newport-Mesa, because in this case, the records were sought by individuals or news organizations who were not in possession of the records they sought. It is the CPRA that's the statutory vehicle required to be resorted to in order to obtain access, inspection, and obtain public records. In none of the cases cited was it claimed that it was necessary to obtain these records for a formal CPRA request in order to shield the requester from litigation. There is nothing in the record to indicate the district or any employee ever posed litigation or threatened litigation if the records were disclosed. In all due respect, this is a red herring brought to protect what is a believed private interest.
Well, why should the employee have to take the chance that this will be the first time the district does it?
Well,
If he's already got it, and
then
it's
why
moot,
not produce it?
why not produce it?
Right, if he already has it, he can produce it,
Well,
and
but
it could have been
what's your
produced.
problem with giving it to him again, or agreeing to give it to him again?
The problem with giving it then to him again is an analysis based upon 6253 and 6254. That's what the district said in its response.
Yeah, and that's what you're trying to avoid.
We are trying to apply an examination of 6254 and 6255 and determine whether or not the records should be turned over. I'm sure that you all are very familiar and have done, like we have done, an examination and a flow chart of these records.
I haven't done a flow chart. Your brief provided me with essentially a flow chart.
Thank you. And if we look at the very first record, the record that was mentioned of October 19th, and by the way, the courts say that these are fact-specific records, this record is entitled Concerns Regarding the Superintendent, Abusive Hostile Work Environment. This is not a complaint of sex harassment against students. It's not a complaint against employees who are underlings. It is a discussion about this individual's belief that the topics that take place that don't agree with his personal opinion in cabinet-level meetings between assistant superintendents is inappropriate because he's not getting his way. Nevertheless, this is called concerns. It's not a complaint, and there isn't any complaint by any individual. I bring this up because, as you know, we're going to balance the public's interest under 6254C with the individual's interests who are being complained of. So far, in the opening remarks, all you heard about was the public interest, not the individual's interests who are being complained of, which you have to balance. There's not an automatic trumping of public interest versus private interest. Also included with this document, and from the very beginning, is communications to the district's legal counsel about issues pertaining to STR's retirement. And included within this document at page 55 and 56 is a legal opinion back from legal counsel on these issues of payroll deductions under CalSTRS. If we turn to the next document that's provided, here we have, starting at page 44, a memo dated October 29th, in which Mr. Caldecott states on page 45, I make no assumptions in making this request, but note that STRS practices and regulations have been a core element in a series of emails. The questions I have posed to the district have not been answered. Now that happens to be his personal opinion, but notice it's not a complaint. It's a question of which he makes no assumption against the agency. Nevertheless, in the documents that were provided, the superintendent asked for a legal opinion, and in the documents you have before you at pages 44 to 46 is a legal opinion in which it is stated that the alleged improper coding of retirement benefits, which by the way is reported from the school district to the County Department of Education to the state of California, are proper. In response to that, we hear, I'm a whistleblower. Now, quite frankly, I agree with counsel, whistleblower status doesn't matter one way or the other. We've cited in our brief why, under the law and the Ed Code, management employees are not quote-unquote whistleblowers. Now we have to compare those interests which are really concerns and which are answered with the individual's interest in privacy.
Yeah, I had difficulty with this in the briefing. This distinction between concerns and interests and complaints, is your position just that because they're called concerns, they don't rise to an important level?
I think that is the first position, and the second position is that when you look at the cases are balancing the allegations that are made of misfeasance, malfeasance, sexual misconduct, or in the ASME case that was cited, a case in which there was an audit and audit findings against the district.
But by the same token, the fact that there aren't allegations of sexual misconduct reduces the interest on the other side, reduces the need for confidentiality. These are not allegations that a person has molested a 6-year-old. They're allegations that the law is being improperly interpreted.
Correct. And nevertheless, if I'm the superintendent or I am the deputy superintendent who has a version of how a proposed management schedule should look, by the way, not one that was adopted, but should look, and I am being accused of not following the law, that does have an important adverse interest upon me when I represent the school board in public meetings, when I deal with teachers, when I deal with community, because I now have a label over my head that I'm committing financial improprieties.
No, you have,
Well,
let's put it this way. If he had called this accusations instead of concerns, would that have increased the weight of his?
you have to, I don't believe that the label is important.
Well, you keep talking about it, these are merely concerns.
And which I believe they are, because once they are reviewed by the board, which the board had a right to review them, it was in effect much like a court looking at a general demur. These allegations that our hostile environment do not rise to the level of anything other than honest debate and differences of opinion between highly educated, intellectual, sophisticated, trained school administrators.
I'm inclined to agree with you. That's why I'm having a hard time understanding why you feel that this has to be kept confidential. Are you and I in agreement it doesn't matter whether he calls them accusations or concerns or elephants, that it's the substance
It's
of
the
what he's saying?
substance.
Okay.
Okay, so we look at the public interest and how serious those concerns are. We balance that with the individual's interest in privacy and their reputational interest, which, by the way, in school administration is really all you've got, is your good name and your word. And now then you have to balance whether or not the public interest in these documentations, which are replete with letters to legal counsel, outweighs the school administrator's interest in his reputation and good name. That is what Markin deals with. And Markin, which was cited by the district in its response, goes through a whole entire group of cases and says, you know what we do is, we look at the concerns, accusations, charges, whatever you all want to call them, and we make an issue of whether or not they are substantive in light of what is being accused of the individual. You have to find that there's substance to that if you're going to allow this criticism to occur to matters which have taken place between high-level employees. The district had a discussion about that, and you see that in Martha Floor's declaration. They had a board meeting in which the board members said, should we make this public? They asked themselves that. They said no, because they believed the superintendent's reputational interest outweighed the criticism that was being made. So that is why I believe that under the exemption of 6254 personnel files, the private interest outweighed making those statements public. Now let me address the next issue. That's 6255. 6255 is the so-called catch-all exemption. It doesn't exist in FOIA. It's unique to the CPRA. And here, the court is required to balance the public interest in disclosure with the public interest in non-disclosure. We're not looking at individuals' interests. We're looking at the public interest in non-disclosure. The recent 2014 LA Unified School District case pertaining to the LA Times attempt to obtain teacher evaluations and test scores has a lengthy discussion about 6255. In it, the Court of Appeals said that in balancing the interests of the public in disclosure versus the interest in non-disclosure, the courts can consider, quote, common sense and human experience. That's why the district produced the declarations of the board president and produced the declarations, I'm sorry, I should have said that in the singular, the declarations of the board president and the superintendent. The superintendent's declaration talks about the fact that too long public education has engaged in smokestack thinking with the HR department over here and the business department over here, and this is my sphere of influence, and don't you get into my sphere of influence because that's what I'm in charge of. That's what this is replete with, is that type of old-fashioned thinking as opposed to a progressive superintendent who wants to hear what these people have to think and to hear them defend in cabinet meetings before they in turn make a recommendation to the school board. Now, that falls, quite frankly, into classic non-disclosure based upon the deliberative process. You know, the deliberative process, as we indicated in the City of Lodi case, includes conversations, discussions, debates, deliberations, reflecting advice, opinions, recommendations. And that is because high-level public employees are to be judged upon what they do, not what they have said in arguments with each other. If you're going to turn over these type of documents, then you're going to cause administrators to keep their thoughts to themselves and to return to their own smokestack decision-making. That is why the board, and I believe that there should be some deference given to the board, as to why it believed in non-disclosure. It's not just a simple thing of, well, this isn't too serious, well, it speaks for itself. I think it's helpful to take it, by the way, from the beginning, because what you will see is it is the adjectives and adverbs that were used by Mr. Caldecott to describe his concerns that were elevated. It was not the subject matter. They were concerns at the beginning. At the end, he called himself a whistleblower, talked about retaliation, and elevated his allegations. But that didn't deal with the substance of the allegations. And therefore, I respectfully submit, as the Court of Appeal did in LA Unified versus Superior Court, that when you examine that interest in non-disclosure and you take into consideration the declarations of the board president and the superintendent, you will see that there is a strong interest in not bringing into question these highly technical arguments for which the legal advice was given as to various issues pertaining to how we credit retirement for what I count is maybe 2 or 3 people in the district.
So what you've outlined to me is a series of terrible things that are going to happen if these things become public. So your position isn't, it's moot, he's already got them, and we're never going to do anything about it. Your position is if he reveals these, horrible things are going to happen. If horrible things are going to happen if he reveals them, why wouldn't you take action against him if he revealed them?
Well, I don't believe that's the correct analysis. The correct analysis is the horrible things that support the public interest in non-disclosure. The public interest in non-disclosure
But why are we then arguing about mootness? It isn't moot. It's important that he not be allowed to disclose these, is what you're saying.
I argued mootness because, according to the LA Unified School District, it says here, the public interest is minimal and has little weight if the documents are otherwise available to the individual. That was the reason for arguing why it was moot. That goes to a consideration of what is the weight to give to the interest in whether or not it overbalances the privacy interest under 6254 or the public interest in non-disclosure.
You said at the outset of your argument that the board has never come down on anyone for doing this, and there's no threat here that the board's going to do anything.
Absolutely, there was no threat. That perceived argument that something might happen to me, we're now a year out, has never occurred. There's not a single word in here or in the transcript that says there's any threat to this employee. It's a question not of threats, it's a question of balancing the reputational interest between the individual or the institution with the public's quote-unquote right to know.
But what I can't understand is if your interest is so great, why aren't you willing to fight for it?
How else should we fight for it? We fought for it by citing Mark and saying we've looked at the allegations, we've considered what you've had to say, and we don't believe they're of substance. There's no obligation in this balancing issue of making non-substantive issues public when you balance that with the reputational interest of the superintendent
Okay,
or the other administrators.
I see where you're going.
Whistleblower, I've discussed. AFSCME case, I've mentioned. Issue about termination is irrelevant. It's not for you as far as his current employment status. I'll be glad to answer any questions, and I do appreciate the opportunity. One last thing. I think it's also important to consider attorney fees are mandatory. I think that when you look at this issue, and after all, this is an equitable matter that's before you in this balancing, when you consider these interests, when you consider what was advanced, I do not believe that, and respectfully submit, the Newport-Mesa Unified School District should be saddled with attorney fees. And therefore, since he has the documents, since there's no threat, the district's actions were appropriate, and the Superior Court's decision should be affirmed. Thank you very much.
Thank you, Mr. Covert. Mr. Crosby?
Well, regarding this issue of attorney's fees, I think the public would have a real interest in knowing why the district presumably spent so much attorney's fees defending Mr. Caldecott's petition and fighting this appeal. If all, as I think Your Honor suggested, all they really needed to do was grant the public records request, and if they believe they're correct in their position and that Mr. Caldecott was blowing smoke basically because he was a disgruntled employee, then let the public make its own judgment. That's the whole purpose of the CPRA, for transparency.
Mr. Crosby, the problem I have with that argument is that it seems to me to prove too much. If the only question we ask is, does the public have an interest in whether the school district is being properly run, the answer is always going to be yes. Nothing will ever be confidential because the public will always have that interest. So how are we going to keep anything confidential if that's the nature of our question?
Well, of course, the cases all mandate that this balancing process be conducted as it should be. And all I'm saying is I'm advocating on behalf of Mr. Caldecott's position that in that balancing process, one must consider, for example, I didn't hear one word from counsel about any investigation that was conducted. Wouldn't that be important to know whether an objective third party looked into these issues? If you look at the 6 issues of alleged impropriety raised by Mr. Caldecott that are stated at pages 7 and 8 of my brief, these are significant issues. Now, of course, we all know that boards and organizations have a relationship with the top person, whether it's a CEO or a superintendent, and they have a concern about maintaining the relationship. But if you look at the letter denying his petition and see that it basically parrots much of what the letter from counsel sends to Mr. Caldecott or to the board about why there wasn't a hostile work environment and why there weren't financial improprieties, at the very least, given the seriousness of the issues and given Mr. Caldecott's position, let alone taking into account that for whatever reason, they terminated him, and if he was doing things that were really improper, why didn't they terminate him for cause? They didn't do that.
But your position is there was no investigation, right?
No, none at all.
So why would the emails pertain to that? I mean, there aren't going to be emails saying we didn't conduct an investigation.
There are emails saying that they promised an investigation by an outside consultant, but again, in the only declaration proffered in opposition was counsel's statement that I determined his complaints had no merit. No supporting reasons because I consulted with this person who.
But I just don't understand how the emails pertain to that. I mean, you've got a declaration that says there was no investigation.
Exactly.
What more do you need? How are the emails going to relate to that?
I'm sorry?
How are the emails going to relate to that?
There are no emails to my knowledge that say there was an investigation.
Then
So,
what-
but my point is that's so important in all these cases because we have people that all have an interest in the outcome. They want to maintain relationships. When there's arguably close questions, they can gloss over certain things and put a spin on things and so on. But if you look at a couple of Mr. Caldecott's emails, he talks about the tremendous stress that he's been under by what he says has been a complete pattern of abuse and retaliation.
How do you deal with Mr. Covert's argument that, and the briefing on this left me unconvinced by either side, frankly. The briefing's lovely, but I'm still not sure where I come down on the argument that if these things are going to be disclosed all the time, we discourage the board from having conversations about it.
Well, that I can appreciate, and that's why one has, in the Markin case, I think there's reference to there has to be sufficient indicia of reliability that the charges have are substantially, are substantial, I guess. And that's the words. And so I submit that the record here demonstrates that there are indicia of reliability. Authorizing compensation for an administrator, which he believed in violation of the standards, shifting it over to the business office instead of doing it the normal way. In one of Mr. Caldecott's emails, he says that if you added up all the hours that they wanted to give this new assistant vice principal so he could meet the compensation he had before, he would have worked something like 13 more hours than there are in a year. So he had legitimate reasons to make sure that they were complying with all the standards that were required. All he needs is a reasonable belief in improper government activity. And I submit that that plus his heartfelt expressions of what he observed going on to his co-employees, to the conduct of the administrator, all of that gives rise to inferences that there are sufficient indicia of reliability. And can there be any question that the response to his complaint by the board of December 10th is not a public record? How could that be anything other than a public record? And for the court to go through and make a blanket statement that none of these documents are public records is just not right.
So just to be clear, you agree with the court's assessment that the documents, will you accept the court's assessment after it examined the documents in camera that a claim of hostile and abusive work environment, that the documents are relevant to that issue? Where you take issue with the court is that where the court decided it's an internal personnel matter. You think it's an issue that the public should have an interest in seeing.
Exactly. In other words, by that reasoning, then they could, if they try to strangle an employee, is that still an internal personnel matter? It's a matter of degree. And where it's a matter of degree, I understand is that there's a balancing. But if there's any sufficient indication that these complaints may have substance, may be valid, then there should be a public records disclosure. And let the public decide. There is a lot of public interest in this case, and and an employee shouldn't be concerned about potential liabilities for releasing such documents.
If in looking at the documents, can the court weigh the strength of the case? I mean, we can all agree, maybe, or let's say the court, a hostile and a dangerous work environment, per your hypo, is a matter of public interest. What if the case is just so weak? Can't the board, can't the government look at that and say, balance the competing interests and decide, well, we agreed in general that a hostile work environment is a matter of public concern, but these facts, this case just doesn't rise to that level.
Well, yes, however, as I quoted from the Axme case, if the board or if the public entity is the only body that makes that determination, then the purpose of the act is thwarted. And there are dynamics that exist in these organizations that cause boards oftentimes to lean to support them.
Okay, can the court make that assessment?
I think that's the whole idea behind the independence of the judiciary and the rule of law, that the court is going to make an objective determination without being any hint of bias. And I simply submit that when the investigator has a real interest in the outcome, and that's his main client, then there at least should be an objective investigation, which there isn't here. And there are plenty of California Supreme Court cases that talk about the importance of adequate investigations in any employment situation. There was not one here, and I think that's paramount.
Anything further?
Thank you.
Thanks, counsel. Matter submitted. We're in recess. Thank you both.